Coming up on this episode of the IoT Inc. Business Show.
GDPR, that's four initials that stand for the General Data Protection Regulation. And this is a new bit of European legislation which comes into force in less than a year. So from the 25th of May 2018, it applies to all companies that process data on European Union citizens.
The GDPR is coming, whether you like it or not. And before you dismiss it as a European thing, take a second look. Because on May 25th, 2018, data privacy is going to change worldwide and forever. The EU is stepping up and leading the world in defining the future of data privacy. In this episode of the IoT Business Show, I speak with Rosie Burbidge about the GDPR, why it's consequential, and why it's going to affect you.
All this and more on this episode of the IoT Inc. Business Show. The people, the business, and the technology of the next generation internet. This is the IoT Inc. Business Show. And now, here's your host, Bruce Sinclair.
Hello and welcome to the IoT Inc. Business Show. This show is for business leaders and managers employing the Internet of Things for their business or the business of their customers. I'm your host, Bruce Sinclair, and I interview the industry's leading authorities to find out how they use IoT to improve business and create value. If you like this show, subscribe to it on iTunes and go to iotinc.com to check out my complimentary articles, videos, meetups, and webinars. controlcenter7.com. Did you know that 60% of IoT initiatives stall at the proof of concept stage? According to a new study by Cisco, only 26% of companies report successful IoT initiatives. What's worse, a third of all completed projects were unsuccessful. Want to avoid the most common pitfalls of IoT implementation and management? Go to www.controlcenter7.com. These recommendations come from Cisco Jasper, whose Control Center is the world's largest IoT connectivity platform, with over 11,000 enterprises, 43 million devices, and over 1.5 million devices being added every month. This is the heavyweight in connectivity platforms, and obviously Cisco Jasper has a lot of IoT credibility. So if this sounds useful to you, support our sponsor and this podcast by going to www.controlcenter7.com and then filling out the contact form to get more information. And let them know that this podcast sent you. With me today on the IoT Show is Rosie Burbidge. Rosie is a senior intellectual property lawyer at the London law firm Fox Williams. She specializes in the protection and commercialization of different types of media, including data and design, both of which are relevant to IoT. Rosie, welcome to the show.
Hi Bruce. Thanks very much for having me.
So I get data and protecting data, but what do you mean by protecting design as being important in IoT?
Okay, so there's two major aspects to design protection, really. So there's one is around the actual product itself,
okay,
and the shape of it. I think lots of people don't get that you can register shapes.
Oh, I didn't know that actually.
So in Europe, there's this sort of what we call a Cinderella right, in that it often gets forgotten. And basically anything that you create, from the date that you make it go public, you've got a year in which to register it at the European Intellectual Property Office. And you can register the shape, the texture. It can either be a photo of the product, a CAD design, or a line drawing. And it gives you a lot more flexibility and scope to get pan-European protection. And then there are all sorts of, as with all intellectual property rights, deals that have been done with other countries that also offer design protection. So countries like Singapore, you can get protection there as well. So it's well worth doing a bit of reading on. I thoroughly recommend it to all your listeners.
Yeah, no, that's interesting. So when you say then protecting design, it's more of a protecting intellectual property, including design, including potentially, I don't know, recipes, including other things too. Or is it just the design that you're talking about?
Well, so design is a really broad word, obviously, which
Okay.
can cover sort of the visual representations, so anything that you put on the outside,
Mm-hmm.
which might also be protected by copyright. And I think, or as I understand it, the sort of scope of copyright protection in the States is quite a bit lower when it comes to applying a design onto an object, particularly a kind of everyday object. I know certainly in fashion, the scope of copyright protection
Right.
is much lower. And design it's as well as having, I would say, broader copyright protection in Europe. It's an additional thing, similar to what are known as design patents in the US, but
Mm-hmm.
with a much more sort of much more scope for tailoring it to exactly what features you think are really original about your product. And more importantly, what features you think somebody else might think are original and they want to copy and rip off, as it were.
Okay. So that's your specialization, data and design then.
Well, all sorts of, I don't limit myself to just those things. I do trademarks and copyright, and I dabble in patents occasionally as well.
Okay.
So no, I've got a very interesting job, Bruce. I'm very lucky.
It sounds like it. Well, tell us, how did you get into IoT? What's your background? And tell us a little bit more about yourself.
Sure. So my IoT journey really began with Alex Deschamps-Sonsino, who is also the person that introduced us.
That's right.
And she is a really fabulous networker, designer, inspirational speaker, and she runs the Internet of Things meetup group in London.
Right.
And is also behind this really amazing IoT product called the Goodnight Lamp. And I genuinely, I can't really remember how I met her, but I got going to the meetups and I spoke at one or two of them. And she got me really interested and aware of the Internet of Things. And through that, more recently, we've been collaborating around creating the IoT mark, which the idea behind that is that there's a lot of sort of, I would say, customer confusion and perhaps distrust of some Internet of Things products, because there have been some quite well publicized issues with some IoT products. And the aim is to basically create a mark, kind of like a trademark, that is applied to products to show that they meet certain minimum standards. So particularly around security and data privacy and service levels. So that's sort of where I'm currently at on my IoT journey. And obviously data is a really important part of that, and people feeling comfortable that their data isn't going to be misused and it's going to be handled. Because as we all know, there are plenty of laws in place, but people don't necessarily always adhere to them. And having this mark which shows that you've gone this step further and you're really thinking about the importance of all of these aspects to your product, I think is going to be really important.
Now, when did you said you started going to the meetup? When did you first hear about IoT and then think, wow, this could be something I'd be interested in, and also Fox Williams could be interested in?
I guess it goes back to around 2011, 2012.
Okay, a few years then.
Yeah. So I'm still relatively new to the party, but it's a really exciting time. And London it's such a tech hub. There's so many things happening all the time. Loads of really amazing ideas, and it's really fun. And I was thinking the other day, there are so many devices that I have that they might not be full IoT in the way that you would define it, but they are connected products, and it's just that. And I don't really think of them as IoT products. I just think of them as a fan,
Right.
So we kind of we're reaching a point where it's just become normal, which is great.
Now, is IoT a blip on the radar yet, or is it actually becoming a significant part? I don't know, maybe not significant, but is it becoming a part of Fox Williams' business?
So for me, it's a really important part of my practice, and the data side of it is really that together with, we do quite a lot of work around the blockchain and distributed ledger technology. So obviously there's a huge synergy between those two technologies there,
Sure.
which I think is really exciting. And actually, some of the security issues could well be solved by some of the blockchain approaches. So,
And what about, Joe? I'm just trying to get a sense, though, how much business is IoT for your firm? You know, is it something that's just starting, or is it actually something that, it's already a line item, so to speak?
I would say it's still in the emerging stage, and we're always happy to get more people who are interested in finding out more. I mean, what we do is offer legal services. So
Sure.
on one level, the business, what they do isn't that important, because what we're selling is the legal expertise. But on the other hand, I mean, I do a lot of work with the fashion sector and sort of relatively mainstream technology companies. And this Internet of Things aspect is creeping in more and more to all of these different businesses, particularly around things like wearable technology and that side of things. So I guess really businesses that you might not think of as Internet of Things businesses are ultimately becoming them by default, because that's where the whole world is heading around. Everything being linked up to the internet, and the importance of data within all of that, the importance of being able to make the most of your data, but also not ending up the wrong side and potentially misusing data. So it's exciting times.
Very exciting, yeah, and that's the tension I want to. One of the things I want to explore in our discussion here is, protecting while using. But yeah, Rosie and we met at the IoT London meetup. That was actually, I think it was the first stop of my book tour. I've been on maybe 5, 6, 7 since then, and that's when we got to talking about privacy and data. And that's going to be the topic of our discussion today. So why don't we start with a brief history of data privacy in the EU up to today, and then we'll get into what's coming up.
Sure. So I think it's fair to say that the European Union has the strictest data protection, data privacy laws in the world.
Right now.
And I think right now and historically, we've always been that much more concerned about it. And I think that really, you have to look at a bit of European history to understand why. I would say a lot of this distrust centers on Germany, and obviously during the East German, when there was an East Germany and when the Stasi were monitoring the population on a regular basis, this created a very strong distrust and concern within the population about the government having access to too much information, and on a slightly lesser scale about businesses having access to too much information. So, I mean, everything from George Orwell's 1984 onwards, there's been this kind of tension and concern about exactly where this all of this information is going and how it's going to be used in the longer term.
So,
Yeah, no. So, I mean, that's the sort of the political and cultural angle. From a slightly less exciting legislative perspective, there was some legislation that began in the 70s, but really the data protection journey begins in 1995. Basically, the European Union, as it then was, which was only 15 member states, they negotiated a directive that was going to set minimum standards across the European Union. And I mean, it's incredibly archaic, because the world that it was imagining was really a 1980s world, because, as you know, with all legislation, it takes a really long time to actually get it passed. And then the way that directives work is that you agree the directive in 1995, and then member states have 2 years in which to actually implement it into their own country. So by the time the UK implemented the Data Protection Act in 1998, we were already dealing with a very obsolete set of laws. And as you can imagine, it quickly became even more out of date as companies like Google, Facebook, they, took off, and this mass data collection across the whole of the world became really normal in lots of businesses. So I think the only other thing that I would say from a sort of historical context is that because of this background, because of the concerns about the Stasi, etc., the sort of the basic approach to data protection across Europe has generally been it's not allowed. It's approaching it as a negative rather than a positive. But because it's a directive, which at the risk, I won't go into too much detail on European legislation, but basically there are two main types of law that get passed. One is a directive and one is a regulation. And a directive sets minimum standards that member states have to adhere to, but then it's up to each member state to say, actually, I want to go quite a bit further.
Right.
So Germany went quite a bit further, but Ireland stuck with the minimum standards. So there is this massive disparity across the European Union, even on what is meant to be a harmonizing law. The difference with a regulation is that it doesn't require each member state to put in its own national legislation. It just automatically applies across the whole of the European Union from the date that it comes into force. So I'm not sure how you put that into an American context, but I suppose it's the difference between waiting for a state to put law in and having a federal law that applies across the whole country without having to do anything.
You brought up something that I'd like to ask you about, and that's in particular kind of the history. And you were saying because of the history of Europe, in particular in Eastern Germany, then privacy has been leading, you've had the strongest privacy protection in the world. And then you said something about the new normal, or the normal of Google and Facebook collecting all this data. I guess what I'd like to ask you about is here I'm finding, and it's not necessarily my generation, but it's my kids' generation, I'm finding that the new normal is they really don't care that much. As long as everybody is very clear with them about this data being collected. So we're going to get into, obviously, the GDPR in a moment, but do you feel that the GDPR is kind of being based on history, or being the energy behind it is based on history, or is it really the population that's demanding it?
I mean, again, I can't really speak for everyone, but my personal take on it is that there is amongst younger people, and I'm probably somewhere in the middle between these two extremes, a very...
I'm one of the extremes, okay.
A very happy willingness to give personal data in return for services. And I think there is quite a sophisticated understanding amongst people, regardless of their age, that they are getting these services in return for, their email being scanned or being sent targeted advertising. And most people are happy with that bargain. But as you say, they understand that that's what they're entering into. But the other thing, I get involved in the recruitment process, and quite often people, their naivety in terms of what they're sharing online does come back to bite them. So I think perhaps things like the right to be forgotten might prove to be more valuable than people realize in the future.
You may not even know it.
Yes. So and also you're very happy to share amongst your friends and to have anyone access when you're a teenager. There's a willingness and an understanding amongst lots of people, I think, that they are giving their personal data in return for getting services. And I think most people are happy with that bargain and understand what's involved. But the difficulty is when people's careers change, or they grow up, and the things that maybe they were happy to share when they were younger, they're still floating around on the internet, but perhaps the context in which their life has gone means that maybe seeing those photos of them, not even doing anything particularly outrageous, but they're not ones that they necessarily want in the public domain. So I think that's one of the many advantages of the European approach, which is to give a lot more power into the hands of individuals over their personal data. Because businesses are making a lot of money from this, from targeting targeting individuals, from targeting advertising, etc. So it's trying to balance out those two things.
Yeah. And the Internet of Things is just the beginning, and it's going to be using it even far more than what we've seen for targeted advertising. So it makes sense, but why don't we use this as a segue to jump into the GDPR? Why don't you explain what is the GDPR? Break it down just in a way that we can understand it.
Sure. So GDPR, it's a nice, not really an acronym, but 4 initials that stand for the General Data Protection Regulation. And this is a new bit of European legislation which comes into force in less than a year. So from the 25th of May, 2018, or May 25th, as you would say, it applies to all countries that process all companies that process data on European Union citizens. So although it will be a bit of European Union legislation, its impact is global, because any business that operates online is almost certainly going to be collecting and processing data on European Union citizens.
Right.
And it's had a lot of press, obviously, across Europe, but I think there's a lot less awareness and understanding of what it means and its wider implications outside of the UK. And the rest of Europe, obviously.
Yeah, no, I can attest to that. A year ago when I was in Europe, I didn't really hear anything about it, not that I was asking about it, but then this year, starting with our meeting, and even before then when I was at a conference, and then with other meetings that I had in Europe and different presentations, it was like a major theme. So there has been, I think, well, at least from my perspective, in the last year, a big awareness of the GDPR, and I guess that's because it's pending and it's coming soon.
Yeah, exactly. Less than a year. I mean, and a year is not very long to make quite fundamental changes to the way that you process your data. So I mean, I thought it would be helpful to set out a few of the sort of underlying concepts that they underpin the approach to data protection in Europe. So the first and the most important one really is around personal data. So this is any kind of data that can be used to identify an individual, and it can be used in combination. So, for example, a device ID on its own, that's pretty innocuous. You can't tell anything from those numbers. But when you combine it with some other information, like maybe the neighborhood that it's based in, or a few other bits of data, then suddenly you can actually work out who that device ID belongs to, or make a really good educated guess. So just because it's not someone's name or email address, it doesn't mean that it's not necessarily personal data. So suddenly IP addresses, tracking cookies, metadata, all of these things could be personal data. And the definition of what's included has been broadened significantly over time. And then the other really important concept is consent. And that's the consent by the person whose data it is, or in data protection parlance, the data subject. And basically the data subject, or the person whose data it is, they have to give consent to the processing of their personal data. And that's just not, oh yeah, sure, like, hey, have my data, do what you want with it. It's, okay, we're going to do X, Y, Z with that data. Are you happy with all of those things? And it now, under the GDPR, it has to be much more informed. So setting out exactly what's planned to be done with it. And it needs to be an active consent. So I don't know if you've seen on many sort of privacy policies and that sort of thing, there's often a sort of a pre-ticked box, or maybe not even a box at all. And the idea is that you can maybe opt out either by unselecting the box, or by sending an email saying, I'm not happy, please can you unsubscribe me, or whatever. But now it has to be, there's a box that you tick, or some other method of showing actively that you consent to that use of your data. So it's quite a sea change as far as the approach, and and the amount of effort that has to be gone into as far, for every single bit of personal data that you have.
Okay, so what you're saying is the two areas here that are maybe different or maybe important to consider is what is personal identifiable information, and you're saying it's not just a name now; it doesn't have to be explicit. So somehow the collectors of the data have to make a decision. I don't know, how do they do that? Because like you were saying, they don't necessarily know all the other data. Okay, well, in some way you're saying you're going to have to abstract it, so maybe you just say an IP address is personal identifiable data. Is that kind of the approach? You don't even have to know all the other data that's being collected.
So the safest approach is to separate out device ID data and IP addresses from the rest of any data that you've collected. I mean, IP addresses, I think there's enough information online for people to backtrack and work out who's behind that. But device ID, not necessarily. If that's kept separate and there's no easy way of linking it, then potentially that's okay. But it's a question of what the European Commission calls data protection by design. So it's thinking really carefully from the outset about how you collect and store that data, so that number one, there's much less risk of it being stolen or misused. So that doesn't necessarily mean hackers. It can mean employees accessing the data.
Sure.
There have been quite a few high-profile cases of employees effectively stalking ex-partners. So, I mean, certainly in the UK, that data would not have been available to them. There would be a very small subset who have access to that data. And then any queries that, say, the finance team want to run, they go through that tiny team of people and they respond and answer to them. So it's setting up systems like that and maybe looking at the way data is stored holistically and in different subdivisions to make sure that the likelihood of something going wrong is minimized, basically.
Okay, so on the outset, it's defining in a more broad sense what is personal identifiable data, or what is personal data, and then secondly, it's saying there has to be an explicit consent, and this is going to have to be with some interface. Sometimes IoT products don't even have interfaces, so that's going to have to be sorted out. But those are the two main. That's where the starting point is, right? A broader view of what is personal data, and then a more stringent or explicit okay to use that data. Is that the fundamentals? That's
the starting point. Okay. But yeah, there are a lot of things that come out of that. So, but before we get into that, I think there are two really important points that I want to flag up to everyone. Mm-hmm. So the first is, as I said earlier, this is a bit of European Union legislation, but because it applies to the data that's processed of any EU citizens, sure, it is effectively globally applicable. And the second is that if you breach the GDPR, the data protection authorities are able to fine to really quite large levels. It's basically the greater of 20 million euros or 4% of a business group's annual turnover. So there's no way of hiding from that, or maybe there is, but the idea is that you go after the whole group, so you can't just say, oh, well, that particular company isn't trading. They're the ones that are responsible for Europe, so you can't go after the rest of the business. Mm-hmm. It's percent of the group's annual global turnover.
And I guess I would assume that the company would have some operating presence in Europe, or does this cross borders? For I guess the prosecution of it, I mean.
I'm not too sure actually. That's because it's all hypothetical at this stage, because it hasn't come into force. I'm not entirely sure how it would work, but I believe it would be down to the Data Protection Authority, and I'm fairly confident that even if they didn't have a European Union presence, that it would still be possible to prosecute them. So you couldn't sort of hide behind being in a different jurisdiction.
Yeah, no, that's what I'm wondering about. Okay, so it applies to everybody as long as you're not as long as you're doing some business with Europeans in some way or form with your product, and then the fines are huge. I mean, 20 million euros. I mean, that's the minimum you're saying, or that is the maximum?
So it's all linked to exactly the extent of the damage that's caused.
Okay.
So it would be about the level of data breach, and also, even if it was a really epic breach, if the company had done everything that they could, that would be factored in. So say they put in really stringent security measures, they'd been really careful about the way that data was stored, they'd had a really clear disaster recovery plan, like done everything right, but still, the worst case scenario happened, that would all get taken into account when deciding on the fine. But the aim really isn't to punish, it's to encourage businesses to put in place the right procedures now, so that there's less likelihood, although of course we know that there's no way of absolutely protecting, but less likelihood of things like data breaches or misuse of data happening.
Well, why don't you maybe take us through some of those procedures? I guess these are recommendations, I suppose, or are these actually you have to prove that you're following these procedures? So how is it structured?
So at the moment, it's all about a combination of things. So the first is a kind of audit of your data. Mm-hmm. So think really carefully about where the risk areas are, and particularly if you're processing what's called sensitive personal data. So that's details of people's health, ethnicity, religion, those sorts of more sensitive information that maybe people would feel particularly aggrieved about it becoming entering into the public domain. And so if you're processing that sort of thing, and obviously financial information, then there's a higher level of due diligence that needs to be done in advance. And then there's this concept of data protection by design. So that is thinking quite carefully about how you approach where data is stored, how it's sent across to other, how it's processed internationally, if that's feasible, dependent on safe harbors and that sort of thing. And it's really about, just thinking and training and making sure that your staff are aware of exactly what they can and can't do and what the procedures are if something goes wrong. So it's identifying who's responsible. There should be a data protection officer in most businesses. Who's going to fix it? So literally who you're going to call, like as in which security consultant or who's on the line, and who do you want to speak to? What backups of data do you have? So, for example, if it's a ransomware type situation, making sure that there is a backup of data that's not too out of date, and who you need to notify. And I think it's really important that people are aware of the notification obligations. Basically, you need to, within 72 hours, have notified a data protection authority. And if you don't, then the sanctions are much higher, and there's you're starting on the back foot, basically.
Okay. Now, and just to clarify, then, so the audit, I understand you're saying, and these are all best practices so far that you've gone through. So doing an audit, so you can actually show where data is and what type of data and so forth, and then protection by design. This sounds a little bit more like internal policy than actual security itself. So just dividing the two, we have the risk is what we're talking about here, and privacy is one form of risk. But then we have the actual technology, which is on the security. What you've been describing of assigning a chief data officer, who fixes what, the procedure. This all sounds like internal policy, which is also very important, and everyone should have this. But does it also cover the actual technology, or is that left to the organizations? No,
that's left to individual organizations. And I mean, as you can imagine, there are lots of businesses out that have identified this as a really good opportunity. I'm sort of chatting to a few different people, but unfortunately I haven't actually seen any products in action, but I'm aware of lots of different businesses that are looking at GDPR compliance and looking at ways to help smaller businesses and larger ones on ensuring that they've put everything in place before the magic date of the 25th of May. We've talked a lot about the sort of the obvious problems, so that's things like data breaches.
Sure.
But I think it's also worth bearing in mind that the GDPR, it brings in quite a few new rights for people that maybe are not so familiar to a global audience, and also steps will need to be taken to make these rights available within specific time periods. So the most sort of, I would say, well-known right is what's called a subject access request. And that basically means that somebody or an EU citizen whose personal data is being held by a business has the right to ask that business to provide them with all of the data that is being held on them. And that now, under the GDPR, will have to be provided freely, so free of charge, and within 1 month.
Wow,
and
okay.
So these things, they crop up a lot in litigation because it's kind of like an easy way of getting early disclosure or discovery, as it's known in the US. And it's very common when people are leaving employment so that they've got all of the information if they're considering bringing a claim or just generally so that in case things happen to the business in the future and they want to have that record of everything that they worked on. So there's that side of things. And then there's data portability. And that's basically the idea that you should be able to suck out your data from one business and push it into a new one, rather than having to start from square one each time. So it's not necessarily a business failing, but maybe you're not appreciating their product anymore, and you want to move it to a new business that offers something similar, but maybe a slightly better deal. So I think that a really good example of this is like a fitness tracker. So if you've spent years getting all of your fitness data together, from, say, your Fitbit or whatever, you maybe would be less inclined to move to a different product if you weren't able to move your data as well. But the concept of data portability means that data has to be put into an easily accessible format. So like a .csv file or something like that can then easily be plugged into a new business. And then you've got that data history there as well.
Okay, that's kind of nice, yeah.
And then the final sort of red letter concept is around erasure of data, or as it's known in the press, the right to be forgotten, which has got quite a lot of press, certainly in the UK, because there's been a long-running dispute between Google and the French government over this. And it's basically saying that it's about deleting all personal data permanently from your records, and obviously that's easier said than done, because quite often a business will have sold on personal data because it's hugely valuable, and if that happens, then you're in a situation where you've got to trace who that data has been passed on to and make sure that they also delete it. So it's quite an arduous task, and many businesses haven't necessarily thought through how they're going to ensure that that's complied with.
Yeah, I mean, in general, it seems, I'm just thinking about this from a technical point of view, this is not easy. There's a lot of thought that has to go into this. And I guess that was kind of one of, so before we get there, I mean, the rights, just so if I understand them correctly, that the citizen or the user has is they can ask for all the data. That makes sense. I love that. The portability, maybe if it's just an Excel file, you're going to have to figure out how to map it in, but I can see there doesn't necessarily have to be any standards there. So you have to be able to, or you have the right to be able to take your data, move it to another product. And then the last one is you have the right just to press a button and erase yourself and erase all your data, or this right to be forgotten. These all sound awesome. I mean, personally, to the person, I'm just now looking at it, or to the consumer, but I'm looking at it from the other side. Before I get there, though, is this generally, at least in the U.S., we have the government stepping in, as is the case here, for the for the consumer because it's a B2C transaction as opposed to a B2B transaction. In a B2B transaction, generally, this is all spelled out pretty explicitly with contracts between the two organizations, generally. In a B2C, you don't have a lawyer that's representing you when you buy that lamp or you buy, whatever the product is. So I guess my question is, does this relate strictly to consumer products, or is it also relate to industrial products or commercial products or infrastructure products? How far does it reach out?
So it relates to any business. I by the nature of what a B2B versus a B2C relationship is, B2C will inevitably have much more personal data that they're collecting. But if there's a B2B relationship and there is data collected about individuals as part of that relationship, then that will be covered as well.
Okay. So it does cover everything, but that's true. It does have to have that, the personal identifiable information, and then there has to still be that consent. Now, so what struck me, and I'd like to get your view on it, but this is arduous, like you said. I mean, this is, from a technical point of view, being a kind of a techie kind of guy, I'm just thinking through what has to happen. It's all makes sense, but it's a pretty big load on the organization that has to develop this. And what I found is, when I was in Europe just recently, a few weeks back, that organizations or people that I spoke to on the tour, and I spoke to a lot, when we talked about the GDPR, it almost seemed like this was the most important thing, and then innovation was the second most important thing. Whereas in other parts of the world, it's kind of the other way around. Now, I'm not saying one is right or one is wrong, but this does take a lot of energy, and then not the whole point, but a very big part of the value of the Internet of Things is using the data. Now,
sure.
I totally am on board with getting the consent, and specifically if it's PII, as we call it, personally identifiable information. But this whole back end that has to be available just seems to me that it's almost like a trade-off. It's a trade-off of fitting, or it doesn't seem like they even have a choice here, but it seems like in Europe, the approach is to build to the regulation as opposed to, let's say, here in the US or in Canada, where it's more the focus on innovation. Yeah, we're going to make sure that we do the right thing, but we don't necessarily have to have this huge back end. I'm not sure where the question is here, but do you get that feeling as well? Because I certainly got that feeling that this was more important than innovation. And to me, that's kind of the death knell, because you need to be thinking about innovation if you're going to succeed to even get to this point. But I understand, there's a balance here. What are your thoughts on that?
So I guess I've got there definitely is a difference in the way that European and North American businesses approach data. I think overall the world is going to move towards more of a data protection focused universe, as it were, and I think in the long run the European businesses will be ahead of the game, because they'll have everything in place to sort of run with this brave new world, as it were. Whereas, you might have North American businesses, Asian businesses stealing a march in terms of, mainstream innovation, but in the longer term, there's going to be either litigation coming from European regulatory authorities, regardless of where you are, or there's going to be class actions from people who are really pissed off about their data being shared without their permission, or there's going to be sort of just wider reputational problems because the data wasn't stored correctly, or you get into these very complicated legal disputes. So I hear what you're saying, and I can see that there has been a lot of distraction around all of this. But I see it as quite a positive thing in the long term, because number one, it enables businesses to get on top of exactly what data they have. So particularly around consent, people can have massive mailing lists, but there's only normally a relatively small percentage that are actively engaged in the product. And this enables those individuals to be identified because they're the people that are opting in, and it sort of it gives businesses a chance to step back and look at where they're going. And do you know what? Actually complying with this regulation, that is going to require a ton of innovation in order to meet the requirements. So I don't know that they necessarily are mutually exclusive. It's not necessarily in creating the most exciting product, but if it's creating trust and a sense of security, then maybe that in the long run is what's going to win the race, tortoise versus hare.
Yeah, no. And like I said, I do completely see both sides. And most of it I feel is reasonable. It's just the rights that we've been discussing and just being able to, do the request, move it over and erase it. To a certain extent, they're all the same, technically. And maybe it's not as big as I think, but maybe it just came from the sense of talking to individuals and companies when I was in Europe that this seemed to be the focus. And you're right. I mean, it's going to require innovation. And I can also agree with you that over time, this is going to be the norm worldwide. It's just this darn, May 25th, 2018, where everyone listening to this, they have to be aware that all of a sudden, I don't know how stringent they're going to be on applying the regulation, but they have to be aware that they're potentially up for, there's some serious liabilities associated with not doing this. And so the question everyone, listening has to decide is, when do we then divert that innovation from things that delight the customers, provide value to the customers, to things that protect the customers? And, and I can tell you right now, security, which again is the technical counterpart to what we've been talking about here, privacy or a subset of that, a superset of that risk, it's not being demanded by right now. And when product managers go out and they ask their potential prospects, would you like, this feature which flashes a red light or rings a nice bell, or would you like higher security? The features of the bells and whistles are always winning. So that's the conundrum, is that your customers aren't demanding it. I know they want it, but they're not, I guess from a relative point of view, they want other types of innovation, yet the government's forcing it. And so I don't think there's any way to solve this, but it does, I think, put everybody into a risk analysis mode, or they need to go into a risk analysis mode and just decide where they're going to put the resources, because this, I think, is going to take, it's not going to be simple, and it's also going to, and since it's very early, I think things are going to be a little bit in flux as to what the definition of each of these rights really mean. I don't know. It's kind of more of just more thinking out loud. It's something that everyone needs to consider, but I think they need to consider that from a risk point of view of, do they move forward to try to get customers and build their business, versus do they put their energy in protecting themselves against the EU prosecution that may or may not happen. You see what I'm saying? I'm putting myself into the CEO's position, and that's probably what I'd be thinking about. I don't know if you have any thoughts on that.
So I think even if you take the risk as far as non-compliance with the GDPR is concerned, there have been some major instances we've had the NHS being hacked, we've had major law firms being unable to access any of their information, we've had a very large UK ISP, a lot of their data was put into the public domain. There have been very high profile instances of businesses accessing employee data or being able to, as I said, effectively stalk individuals based on all sorts of, shopping history and that sort of thing. And longer term, this is going to become less and less socially acceptable, to a point where people were just going to be in disbelief that it was ever the case, that's how we operated.
Yeah, like the wild, wild west. No, I agree, and I think what we're talking about is that period between now and then, and I don't know how long that'll be. But why don't we wrap things up with maybe some recommendations, some best practices that you could offer our listeners? What should they be thinking about now? What should they be doing? What's your view on that?
Sure. So my number one bit of advice is to look on the Information Commissioner's website.
Okay.
So this is it's the UK Data Protection Authority. Their website is ico.org.uk, and they've got lots of really simple, really accessible guidance on what the GDPR means, how you can go about complying with it, what steps you need to take now, what you can maybe, and you know what you don't need to do as well. So enabling you to take stock and go, oh, actually, it's not quite as bad as I thought. Maybe the process that I've got at the moment could just be tweaked a bit. Because it sounds quite dramatic, but I think in many instances it's not quite as terrible. But it's just education and knowing exactly what your limits are and where the bombs are located. I think that's really, really important. And then it's a question of maybe engaging with one of the many businesses that are popping up around compliance, maybe looking at how the more risky aspects of your business, as far as the personal data is concerned, particularly if you've got any sensitive personal data around health and things like that.
Right.
Thinking really carefully now about how that's stored and how it's used, and putting plans in place so that when it all comes around in the 25th of May, you're like, yeah, whatever, it's going to be fine. Forewarned is forearmed, as they say. So set it up now so you don't have to worry in the future.
No, I mean, that's good advice, education and engagement. But it's interesting, I think as you were talking, it reminded me, I believe it was just yesterday or within the last few days, I read a report about the GDPR, and it said something along the lines, you may have heard it. I think only 50% of 80 or 90% of European companies, maybe even higher, knew about it, but only 50 or 40 or 30 were actually doing anything about it, even though we're less than a year away. So, even you can just extrapolate that now thousands of miles away. It just seems, and I don't know if that's accurate or not, but that's something I just remembered reading. But it seems like this is so far away, but, you have to deal with it. I mean, whether or not it's going to be prosecuted on May 25th or not, it doesn't matter, because like you say, at some point it is going to be the norm. At some point you are going to have to do this, or companies are going to have to do this. So yeah, education, engage with maybe some professionals that can help you out. Anything else you suggest?
Well, just on that, I can tell you that suddenly the UK's the Information Commissioner's Office in the UK, they are recruiting heavily at the moment. So I would not assume that it's going to be fine if you're not complying on the 20th.
Okay. You're saying they're recruiting prosecutors is what you're saying.
Well, they're getting ready to make sure that people are complying. I mean, to be honest, the way that they operate at the moment is pretty fair. They work with organisations to help them to comply and to put in better practices. It's not, as I said earlier, the aim isn't to be punitive, it's to encourage good behaviours. So again, like engaging with them now, that's a really positive step that you can take, and thinking, having one person who's responsible for this within an organisation, again, that's a really easy but sensible first step.
Yeah, whether or not this was looming or not, I agree with you. Well, Rosie, that was very informative. I will include the ICO website. Any other? How else? How can people get a hold of you, or how can they reach you, and how can they reach Fox Williams?
Sure. So you can get hold of both me and Fox Williams via Twitter and LinkedIn. And if you don't have the links already, I will send them to you. And you can also find out more about our data protection practice on foxwilliams.com. So if the worst does happen, you can get in touch with us and we can guide you through. Yeah,
or just maybe even before the worst happens, right? Just to get some advice. I think that's
exactly. Yes. Sorry, I'm a litigator, Bruce, so I'm always got my scenario. But yes, there is a lot to be said for getting ready in advance.
Well, I think everyone wants to have Rosie on their side. Rosie, thank you. And I'll include all this information, like I said, for everyone in the show analysis notes. And we'll talk soon and get an update on things.
Lovely. Thanks, Bruce.
Okay. Well, that was episode 90. Pretty good number. 3, 2, 5, all the basics. Get an analysis of this episode, links to things that we mentioned, plus a transcript of the episode by going to iot-inc.com/podcast. If you've been enjoying this podcast, subscribe to it. That way you get every episode delivered right to your mobile device. And there are 3 ways you can support it. You can share it on your blog. You can share it on social. Just go to the show analysis notes and click one of the social buttons. Or you can leave a rating or a review on iTunes. To do this, go to www.iot-inc.com/iTunes/. It only takes 1 click or a little bit longer if you want to write your thoughts. I'm your host, Bruce Sinclair. Thank you for listening. Until next time, may your path to IoT business be a conformed one.
You have been listening to the IoT Inc. Business Show.